Hello again. This is your instructor for the class of Labor Relations in the Public Sector, Mariana O'Brien. For Module 3, Grievance and Conflict Resolution, I have prepared two videos. In the first one, we reviewed that conflict arises between employers and employees and a set of administrative procedures to address them before they escalate into a strike. The first video showed impasse resolution techniques during the negotiation phase of the contract. In this video, we will see how conflict can occur during the contract interpretation and implementation and how to address disputes. The key to a healthy and stable employment relationship is to manage conflict and controversy over interpretation and implementation of the contract in a constructive manner with due consideration of the rights and responsibilities of each party. As stated previously, conflict may occur in regards the implementation and interpretation of the contract. But what is the contract? The contract is the document that defines the terms and conditions of employment. This document serves as a legal foundation for a shared decision-making process between labor and management. It is enforceable in the courts and provides rules of governing the parties' relationship through the provision of duties, rights, and responsibilities among these parties. During the negotiation of the contract, parties agree to a set of provisions that can be fixed, contingent, and the dispute resolution procedures. Fixed provisions usually remain unchanged over the life of the agreement, while the contingent provisions are intended to govern union or management actions in a changing labor relation environment. In order to avoid conflict, parties must design the contract minimizing ambiguities. Some strategies are to avoid excessive legalism, be precise, outline procedures carefully, use examples for clarity, and proofread by individuals who weren't present. Another strategy is to disseminate the agreement. While administering the agreement, it must be implemented in a uniform and consistent manner by both parties, and always maintain open communication channels. Grievance is an employee or union, but also a management complaint arising out of dissatisfaction with some aspect of the contract or the work environment. Grievance or dispute resolution procedures are designed to resolve conflicts arising from contract interpretation and application. Employee grievance can be resolved by management unilateral decision if they are willing to cooperate, by civil service procedures through a process of unfair labor practice, or by contractual grievance procedures. The negotiated grievance procedures are established in the contract by mutual negotiation between union and management, while the civil service grievance procedures are established in the statute or by the employer. There are several federal sector grievance procedures depending on the area of conflict. We are very familiar to processes based on equal employment opportunity discrimination, to name a few. Typical causes of conflict arise by the misunderstanding that are result of ambiguities in the negotiated contract. Intentional violations usually involve management intention to not comply with one of the provisions of the contract due to short budget, etc. Symptomatic grievance are indicative of some underlying problem, such as environmental factors that induce complaints among the parties. The number of grievances in an organization can be attributed to the following factors, such as demographic. Grievants tend to be younger and with more formal education. Another factor is the ineffective screening process from the union that failed to shut off frivolous complaints. On the other hand, a small number of grievance procedures may indicate the lack of faith in the process from the part of employees that prefer to resign and leave the organization. Another factor of a small number of grievance procedures in an agency is the existence of alternatives such as the civil service or the federal service procedures. Grievance processes can be long and tedious. This is an interpretation of figure number 10.1 on your textbook, page 317. What I'm trying to show here is that from the moment that an employee, for example, reports an alleged contract violation, it can take almost 110 days before it hits to arbitration. And we will see later that after arbitration, the decision can be appealed and be taken to court. So let's list these steps. The first step involves an informal procedure. Employee goes to the immediate supervisor expecting to solve the problem immediately. If it's not possible, it goes to the union steward. In this step, the union is involved. Together, the employee, counting with the representation of the union, goes to the department head. If the issue is not solved by the department's head, then it goes to the steward or the agent of the union and becomes a formal labor management issue. If the complaint remains unresolved, the labor relation manager and the union committee decide a comprehensive settlement to end with the dispute. If agreement is not reached, then it is brought before a third party or arbitration. Now, if you are an employee and you need to be represented, you would be represented either by the union steward or the union or your personal lawyer. Unions have what is called the union duty of fair representation, meaning that union must represent fairly, honestly, and in good faith all employees, members, and non-members of the union, even if they don't pay union fees. Union violates its duty of fair representation when acts arbitrarily or discriminatorily or in bad faith. For example, when a union refuses to represent an employee because it's not a union member. Our book talks about the case of an employee that when he lost his cause, not only sued the employer, but sued his union for breach in the union duties of fair representation. Federal employees cannot sue their unions because the Civil Service Reform Act provides an alternative. At a state and local level, representation is determined by state courts or the public employee relation boards or commissions. In grievance arbitration, an outside neutral is brought in the parties to review the facts and hear the evidence and testimony favoring each position from the union and the management. But first of all, before a grievance can be taken into arbitration, the dispute must be found to be arbitrable. There are two types of arbitrability: substantive arbitrability, when the contract and the law specifies it, and procedural arbitrability, when there is a problem in the process of complaint. The grounds for arbitrability are decided by the arbitrator. And for example, if the issue brought for arbitration is not contemplated in the scope and definition of grievance in the contract, then it does not proceed. The same situation happens when the issue at hand is considered part of the management rights under the contract. As a reminder, management rights are all those provisions that are listed as non-negotiable under collective bargaining. For instance, decisions over the arbitrability of a case depend on government jurisdiction, but as a general rule, statutory rights overweigh contractual rights. For instance, according to the law of equal employment opportunity, there cannot be discrimination based on gender, age, etc. However, if the contractual rights allow any sort of discrimination against a person because of his or her age, the law supersedes the contract. In addition, arbitrators, not judges, should resolve labor disputes. A mixed option is juxtaposing the legal scope of bargaining and the subject of grievance to decide if should be submitted to arbitrators. Courts have overturned arbitrators' ruling if they violate public policy, previous court decisions, or common practice. Even though arbitrators should resolve labor disputes, if it is proven that the arbitrator has violated public policy, previous court decisions, or common practice, courts can overturn their decisions. Grievance arbitrators, like interest arbitrators, are usually selected from rosters provided by these different organizations, such as the Federal Mediation and Conciliation Service, the American Arbitration Association, and the National Academy of Arbitrators. Just to be clear, grievance arbitrators are those who intervene in issues after the contract was signed and approved, while interest arbitrators address impasses over contract negotiation issues. Some problems in grievance arbitration are time and money. We have seen that within the organization it would take 110 days just to go to arbitration. From there, the process can be extended, being very time and money consuming. Some strategies used by arbitrators in their decision making are standards over interpretation. First, popular meaning takes precedence over special meanings if there is a conflict of interpretation. When there is a problem in the interpretation of a specific term, technical words ascribe technical meanings unless the local usage establishes different. Specific provisions overrule general provisions. For instance, all employees can leave 2 hours earlier on Friday except health department employees. Expressed inclusion in a contract means that those not listed were intentionally excluded. An example of this measure can be, on Friday, assistant professors and associate professors can leave 2 hours earlier every Friday. This means that full-time professors cannot leave 2 hours earlier. Finally, the intent of the parties when the language was written is considered. Therefore, it is important to save notes, rough drafts, and other sources that can be examined to help the arbitrator to make his or her decision. These standards can be found in past practice example, prior bargaining record of the parties, previous arbitration awards, and the burden of proof rests with the party that brings the action to the table. Research shows that gender, experience, training, and occupation are not important determinants on who wins the case. Grievance procedure in the federal government can be tracked to Kennedy's Executive Order 10988. It allowed agencies to develop grievance and appellate procedures. However, advisory arbitration was the final step. It is Nixon's Executive Order 11491, which established negotiations, including binding arbitration, to serve as an exclusive method for resolving grievances over the life of the contract. Because arbitration is a long and costly process, there are new alternatives for grievance arbitration, such as expedited arbitration, also known as instant arbitration, where in an informal atmosphere, an award can be issued in 24 hours and is written in 1 page or less. Alternative dispute resolution is a process used to settle disputes by using techniques other than litigation. A mediator acts as a neutral third party to facilitate an agreement by conducting meetings and coordinating discussions. Facilitators assist parties in having effective and productive communication regarding all types of matters that may or may not involve employment disputes. Grievance mediation is similar to interest mediation. Mediators may use directive or non-directive, or a combination of both strategies to facilitate a settlement between parties. An ombudsman is a representative that acts as a mediator. Peer review is a panel of employees and employers who listen to both parties' arguments, review the evidence, and may issue binding decisions. With this, we are finalizing Module 3. If you have any questions, please send me an email at mobrie13@uwyo.edu. Thank you.